Thank you all for coming. Most of you know me. My name is Vicki Swinetek. I'm a realtor with RE/MAX, and our main office is actually just down the road here at 500 Delp Road. But I'm a member of the Bridge team, and Nathan back here, Nathan Krotzer, we have two Nathans here today. Nathan Krotzer in the back is my team leader, and also here from the team is Kahea Falkman. Falkman, did I pronounce that correctly? Okay. We are located at 424 Locust Street in Wrightsville, but we're just a few blocks up from the John Wright restaurant. Where I live in Bainbridge I'm like perfectly positioned to sell in Lancaster and York counties, and that's what I've been doing. So we have 5 agents, and we also have Sue, who's our transaction coordinator, and we have James, who is our social media, marketing, operations manager. And we're a very hard-working team. In March, we were named one of the top 100 producers in the Northeast United States. In fact, Nathan, I think we were number 26, I believe. Is that correct? Do you remember? 26, okay. So I met Nick Saxton through my work. He works for Nicholas and Hohenadel. They do a lot of our title work. And they have offices in Columbia, where Nate's at. They have offices in Lancaster, Corryville, and E-Town. Nate and I both graduated from Penn Manor High School and Millersville University, although I may have been a few years ahead of him. He went on to graduate from Widener University and got his law degree, and he is now a partner at Nicholas and Hohenadel. So thank you, Nate, for being here. I really appreciate it.
So sorry we didn't get to cross paths at Millersville.
Darn.
Eventually,
Yeah, exactly.
As you said, I've been with Nicholas and Hohenadel for about 13 years now. And although I do a lot of work with real estate, I'm a licensed title agent for the firm there as well. I do a lot of estate planning and estate administration as well. And that's why we're here today. So I don't want to just kind of stand up here and talk at you. Make this interactive. If there's any questions, concerns, anything like that come up, feel free to interrupt, and we'll just kind of address what it is you came here to hear about. But at the outset, I have to first disclose that anything I say is not to be taken as legal advice, and that this presentation does not generate an attorney-client relationship with us. So with that out of the way, just kind of start with the big picture that from an estate planning standpoint, there's 3 kind of main areas that we like to consider as attorneys to make sure that you as an individual are protected. 2 of them take place while you're alive, and only 1/3 is relative to after your passing. So starting with while you're alive, if you haven't already, it's important to consider having what's called a power of attorney or a durable financial power of attorney. This is something that a lot of people overlook until it's too late, because it's a document that will protect you in the event you're not able to act on your own behalf. It designates an agent that can kind of help take care of things either financially, transactionally, decision-making for you if you're not able to. Generally, they're valid immediately upon you signing them, but there are steps you can take to kind of restrict what somebody can and can't do. And that's just something that, like I said, is good to put in place earlier the better, because if you wait too long and you lose any sort of mental capacity as you age or end up in an accident and you don't have the ability to then execute that document, you can be in a world of hurt because things need done and nobody has the legal standing to do it. On that same kind of path of thinking, there's what's called a healthcare power of attorney or an advanced healthcare directive. And you guys may have all seen these come through doctor's offices, or if you've had to go into the hospital for a surgery, they ask you if you have a living will or an advanced care directive. Word of caution, if you've executed them at the doctor's office or for a medical procedure, those are generally limited to that instance. So it is worth having a durable or long-term healthcare plan. This document comes into play if you're at an end-of-life healthcare event, meaning you've suffered some sort of health event in which you cannot fully recover from. There's nothing that the doctors can do to cure you, but you can be made comfortable or provide palliative care during the rest of your life. And this is your chance, while you have the wherewithal to make decisions, to say what you do and don't want in that situation. And also directing, again, another individual who can make those final decisions and authorizations on your behalf. Things like respirators or ventilators, feeding tubes. People don't think about, they know they want them or they don't want them, but the hospital can't take somebody's word if they don't have the legal authority to make that decision. So it's another thing that is good to put in place now, although it's never pleasant to think about. It's better to have it in place and not need it than not have it in place and ultimately need it. So those are the two kind of areas of estate planning that are relative while you are alive that we like to cover. But the big one that everybody then talks about and knows about is once you're dead and gone, it's the will. So the will is important because it is, again, your chance while you're alive to kind of dictate and administer your estate or everything that you're having while you're alive, saying where it goes once you've passed away. Basically, who gets it and who's in charge of making sure that happens. You want to make any gifts or anything like that to charities or friends, that's your chance. Put it in writing, get it down there. That's your legal document that says this is what's going to happen when I pass away. One question that always comes up with respect to wills is, where does it get filed? It doesn't. It's your own personal kind of document that stays with you privately unless and until you pass away. And at that point, then it would get filed with the court. So anything you put in those documents stays kind of private and confidential to you. And that's just one thing that I think is important for people to understand, that not everyone's going to know what you're putting out there right away. So those are the three kind of main bullet points we like to talk about when it comes to estate planning. And then through those, there's a whole kind of bookshelf of, well, what do I do in the meantime? What if I don't want to have $1 million of assets when I pass away, and then those have to be subject to things like inheritance tax or probate? What can I do with it now? There's a whole host of reasons, and I don't want to kind of go too far down any one particular narrow path unless there's questions regarding it. But one area I do want to highlight is about gifting. People always ask me, well, can I just gift things now? And there are pros and cons to gifting, because yes, you can gift. Currently, there is an $18,000 per donee or per recipient of gifts that you can make without having to worry about any sort of tax liability. So you can give a child, a friend, a neighbor, $18,000 per year at the 2024 rates, and that's free of any tax or liability. Obviously, you want to be careful in the amount you're gifting, because ultimately you still need money to survive and make sure that you're taken care of. And beyond that annual exemption, there is also a lifetime exemption. Currently, I think it's about $13 or $15 million. I don't want to guarantee that rate, but that's about where it is. And it's just, if you would exceed that $18,000 per year, you may be obligated to file a return. So to back up, the IRS says if you give more than $18,000, anything above that is subject to a gift tax that you would be responsible for in making the gift. However, if you have not exceeded your lifetime exemption of that multi-million-dollar amount, you probably don't have to actually pay the tax. You just have to file a tax return that says you gave additional gifts. And that's one thing that I think a lot of people overlook, is that people say, oh, well, I can only give $18,000. That's not the case. If you're in the situation where you have resources that you want to give or spend down, you have that ability to do so. You just have to file additional paperwork in order to cover it.
Question,
Yes,
that 18,000 per recipient?
per recipient. It's
You have two children.
If you have two children, you can give $18,000 to each one. If you're married, each parent can give $18,000. So each spouse can give $18,000, so you've got $36,000 per married couple that you can give to each child. And so that is a really good way for people to dispose of their assets while they're alive, to make sure that they're getting to where they want them to ultimately get to. They can see the benefit of them, and then they're not subject to the inheritance tax within reason. The Department of Revenue in Pennsylvania, we're one of 6 states that still have a state inheritance tax. No idea if it's ever going to go away, but we're stuck with it for right now. Presently, you've got 0 tax liability if you're giving anything to a spouse, 4.5% taxes to children, 12% taxes to brothers, sisters, and then 15% tax to any unrelated or non-lineal ascendant or descendant. So if you would make these gifts but ultimately die within the year, Department of Revenue says we're allowed to look back 1 year to see if you've made a gift without getting reasonable value for it. So just bear that in mind. If you've got somebody who is in hospice care or on very short term, gifting is probably not a legitimate avenue for them. So it's one of those things where if you want to make gifts and you know you want to make gifts, don't wait till the last minute, because it's going to defeat the total objective that you're trying to achieve. The other concern with gifting comes in place of Medicare and Medicaid in receiving benefits. Medicaid is the state program that offers assistance to people who cannot afford their care. I am not a Medicaid expert. We do have an attorney in our office who is. His name is Michael Grob. I did put his card over on the table if you would be interested in learning more specifically about Medicaid. But in order to receive Medicaid, you have to have limited assets, which if you step back and think about it, it makes sense. It's a state-funded program using taxpayer dollars. They're not in the business of taking care of people who can otherwise afford to take care of themselves. But there are resources that you can do or utilize in order to qualify for Medicaid if at first glance you otherwise wouldn't. So asset protection in either transferring assets to spouses or children or other loved ones in order to come under the required threshold are avenues. Gifting, however, can be tricky because Medicaid has a 5-year look-back period. Under the current regulations, they can look back 5 years to say whether or not you gave assets away without receiving fair value for them. If that's the case, there are steps you would have to go through in order to prove or spend down that amount before you qualify for Medicaid assets. And that can be difficult when you no longer have assets. So somebody you'd have to turn to, whether it's whoever you gave the gift to say, I need you to compensate X amount of dollars before I can qualify for this benefit and get taken care of. That's not to say it can't be done. Again, there are methods and avenues in which you can protect those assets and spend them down in the appropriate method. There's just specific avenues you want to make sure that you're addressing, and everyone's situation on that field is a little bit different. It's very case and fact specific. So there's no kind of general do X, Y, Z and you're good. It's very dependent on your individual situation. So if that's the case, that you have those questions, please contact an attorney who is familiar with Medicaid, and they can make sure that you are taking the appropriate steps to not subject yourself to that look back or any sort of harm in that regard. Just wanted to also touch base about, not necessarily about estate planning, but about Medicare. People often confuse Medicaid with Medicare. Medicare is kind of the health care provided by the government once you hit a certain age. From an estate planning standpoint, the biggest ticket about Medicare is that you make your application on time. there is a penalty if you do not apply for Medicare, even if you think you don't need it or don't want it. If you miss the application deadline, it's a pretty steep penalty and it sticks with you for the rest of your life. So it's important that as you're approaching Medicare age, you are taking the appropriate steps to make sure you are at least applying. If you never use the benefits, that's great. The state and the government will love you for that. But if you don't, they're pretty quick to impose those penalties on you.
Can you give an example of what you mean?
Well, it's just a matter of,
If I don't sign up for Medicare?
if you don't sign up for Medicare, Medicare then has the ability to impose penalties on you, financial penalties. Let's say you failed to apply. If you now are applying in the future, you need to pay this penalty, and then your rates are going to be astronomical in order to get care. So it's just important that you apply within your deadlines. Okay. As it's an insurance product, we're not licensed in insurance sales or anything like that, so we don't help the application standpoint. I didn't bring any brochures along, and I'm not kind of here to speak for their behalf, but one outfit that we have worked with very closely is a group called Landis Financial Advisors. They do have a Medicare team that helps kind of evaluate your situation and make sure that you're applying for the best Medicare product for your situation. Any sort of advisor like that should be in a position to advise you on your situation without cost. If you're in a situation where somebody says, we can help you advise on your Medicare needs, but it's going to cost you X amount of dollars, that should be a red flag. You can get that kind of help and assistance for free from multiple providers. So I would just say, shop around if you get those pushbacks and just be aware of what it is that you're walking into. So I kind of wanted to take a step back then and just see if there were specific questions or concerns or areas that people had questions about that they really wanted addressed. Yeah.
We're talking about estate tax in both state and federal.
Yeah.
There's a threshold point at which it happens. It's not like you have $1 and the state's gonna say, we'll take 50 cents. Is there a
So
point?
from a state perspective, there is not. There is automatically inheritance tax on whatever is inherited. So it's triggered immediately, regardless of the value of the estate. But if nothing is actually inherited, say that there are bills and expenses that exceed what you have, then you have what's called an insolvent estate. All the money is used to pay your debts and bills. No money is actually going to any heir or beneficiary, so there is then nothing to tax. So there is still a tax in place, but nothing is subject to it. You still then have to just file a return with the state showing that nothing was subject to tax. The vast majority of estates are also excluded from federal estate tax because federal estate tax only comes into play once you're at about $15 million of estate value. So if anybody here is subject to that, take my card. We can talk later now. It's very unlikely, and those people know going into it generally that they're going to be subject to it, and they have plans in place and have positioned themselves, whether it be through various trusts or charitable giving, to help limit their exposure to the federal tax.
Question on power of attorney.
Yes.
Suppose you are a single person
Yes.
and any children you have are not distant states. Who would you go to serve as a power of attorney?
There's no requirement or hierarchy of who to go to for power of attorney. It's really a personal question to who do you trust to take care of your affairs, who is going to best represent your interests and what you would or would not want, and who's willing to do it. With the increase of technology and the advancement of technology, foreign powers of attorney are not as difficult to overcome as they once were. The hardest part about that would be their execution of documents. But generally with things like financial power of attorney, everything can be done remotely, online. There are institutions across the states that help facilitate a distant power of attorney. The more crucial in-person power of attorney is more likely in the healthcare aspect, that you're going to want somebody there at the doctor's office or at the hospital to authorize the giving or withholding of treatment. And in most cases, when those kind of unfortunate situations arise, family is quick to respond and come into town if need be to help care for loved ones. So to really kind of get to your question, it doesn't matter. It's whoever you're comfortable with. It can be a neighbor, it could be a friend, anybody who is just able and willing to do that for you. Okay. Yes.
We'll go back to inheritance tax.
No problem.
If there's very little money
Mhm.
in the estate because the bulk was being given to beneficiaries of retirement, are they still responsible for inheritance tax? Or who's responsible?
So when it comes to what we call non-probate estates, which are items that have beneficiaries attached to them or joint owners, joint accounts would go directly to the joint owner. Accounts with beneficiaries, so you're thinking 401ks, IRAs, those would have beneficiaries tied to them, that those accounts are then going to be distributed right to the beneficiary. Technically, yes, there is inheritance tax on those assets. If the money does not actually come into the estate in order to pay them, what is done that during the filing of the inheritance tax return, it's indicated that separate billing should be done for those beneficiaries. That you just basically alert the state that says, these assets did transfer to these beneficiaries in this amount. This tax is due, we acknowledge that, but we don't have the money to do it. Please go after these individuals for your money. So that kind of, from an estate standpoint, washes the hands of the estate, says we disclosed it, we accounted for it, we just don't have the ability to pay it, these other people do.
And so your executor would then
Say,
reading that.
you've got to go after Sally for her share of the inheritance tax. Yeah.
I wasn't sure who was responsible for pounding it out of them.
Yeah. So there could be some pushback as to whether the estate or the attorney wants to get into that, but ultimately the state will go after them for it. And one note on that is that life insurance in particular is one asset that is excluded from inheritance tax. So if you have life insurance policies with a beneficiary, that will go to them. There's no tax on that.
Well, inheritance IRAs and 401ks, I understand the law has changed and now the recipient has to liquidate those within 10 years.
Yes, under the current law. So it's hard for us to make plans with respect to assets or classes that can be easily adjusted by legislation. Our government is fickle, and anybody's guess as to what they're going to do year to year, if they're going to kind of reauthorize different provisions or modify them. But yes, currently inherited IRAs, you do have to liquidate them within 10 years under the current regulations. But the same thing applies, though, that you could roll them over into a different protected asset from the individual if you're eligible for it. But from an estate standpoint, we kind of take it as that snapshot in time, and then the estate is done with it. Yeah. Yes.
Say you own a property and you know who you want this property to go to, would it be wise to get that person's name on the deed before your death, or just have it written?
It's hit or miss. It's very similar to a power of attorney in that, it's really a question as to what works best for you. there are pros and cons to it. Adding a child to a deed can help facilitate that transfer of the asset to them. Say you have a son, you just add your son's name to it as a joint owner. Something happens to you, your son now acquires that property. However, during your ownership, you've owned half and he owns half. So he's still going to be inheriting half the property upon your death. That half that property will be subject to inheritance tax. It will be substantially less than if he inherited the whole thing. But then on the flip side, during your life in owning it with him, you're now subject to wanting anything to do with that property, you need his approval or sign off on. So you're bringing one more person into ownership that something you've worked your entire life to kind of acquire and pay off, you're now giving up some control on. And that doesn't sit well with everybody. So it's just a kind of a question as to what works for you, how much do you trust the person coming in, and what are your ultimate plans with that property. Vicky?
Quick question about bank accounts. Is it still acceptable to put like payable on death on them, transferable on death, that type of thing?
It is. Various institutions, they kind of set them up different ways. Whether you're in a credit union or a bank, they all have different procedures and internal regulations that they follow. So if you have accounts that you know want to go to certain people upon your death, talk with your financial institution about how you can acquire that arrangement. That type of arrangement, it's still kind of subject to inheritance tax, but it does help facilitate the process of getting the accounts directly into those people's hands without the middleman of the estate stepping in and taking up time.
I have a question too.
Yeah.
I think at one time you could transfer your property to your relatives without any tax. Did that go away then?
Well, there is two taxes when it comes to property. If you're talking about inheritance tax, we had talked about that you can do that free of inheritance tax if you live more than 1 year from that gift. If you pass away within a year, the state has a look back that they can say, you gave this property away, it's subject to inheritance tax.
If you die before the 1 year.
Correct.
Okay.
There's also something called transfer tax, but I want to make sure you weren't talking about that. That's on any sale or exchange of real estate. But between certain family members, it is an exempt transaction that there's no transfer tax.
Okay, thank you.
And the Medicaid thing would involve the house too?
Medicaid involves the house too, and again, that is a 5-year look back under the current regulations. One caveat to that is we had talked about kind of asset protection with respect to houses. If you have a child who is living in the home with you, it's a good avenue to try and help protect that house by deeding it into their name. That is one allowable gift that if you get it into the child's name, who is living there and providing for your care, it can help protect that asset from the Medicaid. Okay. But again, everyone's situation a little bit different on that it's important to assess that situation and its particulars at the time. Yes.
Call the question. We only got married less than 2 years ago. And
Congratulations.
thank you. We moved into my house, which is in the deeds in my name only. So if something happens to me because of our will, he would automatically get the house, correct? Or do I need to get his name on my deed? I guess.
It's a question as to, there are a lot of things that could potentially come into play there. One is, whether or not there were any children prior to your marriage, not on your side. And also if there are any kind of debts and responsibilities that are yours that the home could potentially be needed in order to satisfy those debts. If it is solely in your name, it is still subject to the estate claims. So if it is your intent to kind of make that a unified asset protected by marriage that is a joint asset, then it would make sense to do a new deed from you to the two of you, putting it into joint names.
And at that point, it is kind of excluded from your estate to the extent that it would not be subject to any creditors of your estate because it is not a sole asset of yours. It's a marital asset that would transfer automatically to them.
Are you gonna talk about, cause I didn't know about, like, if one of us would need to go into a nursing facility or long-term care, how to protect your home from getting taken from that facility?
So I don't mean to laugh, but people say taken by the facility. And I just, everybody does it. Yeah, you hear the horror stories. That's what everybody's perception is. That's not what happens.
Okay,
It's the facility says, here's what it costs for your care. And you say, okay, well, insurance will cover this or Medicare will cover this and we'll write the check out for the rest of it. If you don't have the money to write the check out for the rest of it, that's when you're looking for Medicaid to help step in as a resource to pay that balance for long-term care. And that's where
you sell the house to get the funds.
well, if you sell the house to get the funds, you would have the funds. But if your intent is to kind of avoid selling the house, that's when you are working with Medicaid to make sure that you only have the minimum allowable assets under the Medicaid statute to make you eligible for Medicaid assistance.
I always thought the house was considered an asset.
It can be. If you have it in joint names and the non-recipient spouse is, or the non-applicable spouse is remaining in the home, it can be protected. Or if there are situations where it is an intent for the recipient of care to ultimately return to the home, it can be protected. So that's where it gets into that everybody's situation is different and there's no universal yes it's excluded or no it's not. It's really dependent on your particular situation and your arrangements and what you're able to protect and not protect. But in general, if you can put it into spousal names and only one spouse is looking to receive assistance, the other spouse is going to keep living in the home value could be an excluded asset in order to qualify for Medicaid.
You speak about trusts.
Trusts. I have a love-hate relationship with trusts. And a lot of that stems with we're in Pennsylvania. Pennsylvania being, again, one of the few states that does impose an inheritance tax on assets, has drafted their laws in order to kind of pierce the protection of trusts. So the majority of trusts that people think about don't really achieve what they're intending to achieve. The whole idea of a trust is, you put money aside that says it's not in my personal name. It's in a trust that, I'll get some income from it. And then ultimately when I die, it'll go to XYZ. Pennsylvania says, but if you're receiving income from it or you have any kind of control over it, when you die, we're still going to subject to inheritance tax. And a lot of people say, well, that's not what I want. What can I do to avoid that? And in Pennsylvania, the only type of trust that you can do to avoid that is either a special needs trust, which is directed to an individual that has a specialized medical or healthcare need, and has spendthrift provisions in it that really only that individual benefits from it, and nobody else has control in order to cancel or remove it. Or you have a non-revocable trust that you put the money in the trust, you can't touch it, you don't benefit from it. It's basically a gift away now, but the recipient isn't receiving all of it at one time. They're receiving it through the trust, but your control over that asset is completely gone. And it's at that point that trust then is going to be protected from inheritance tax or not subject to inheritance tax. And I say it's a love-hate because for the majority of people, those structures don't work. Giving all away your assets, you need them. Most people's biggest asset is their house, that they can't really put the house in a trust and then not benefit from it. You need to live in it. You want the ability to sell it if you need to, or you want to move. You don't want the trust to own it and the trust to then be with the one receiving the benefit of it, or any sort of income if you would sell it. because it defeats your personal best interest. So again, unless you're one of those people that has the multi-million dollars and you have a lot of disposable assets that you truly do not need to live off of, then those irrevocable trusts can be a good provision or an avenue to help protect some of your assets from inheritance tax laws. So I'm not here to sell you a trust. Okay? Yeah, unfortunately, there were in the past there were a lot of different kind of bandwagons that came through and put on presentations and sold trusts. People signed up for them. And unfortunately, a lot of my practice and my partner's practices was undoing those trusts because they didn't do what the people thought they were going to do. And they really made their lives more cumbersome by not protecting the assets, requiring them to file additional tax returns every year in the name of the trust, and just really kind of mucking up their personal lives.
I appreciate you saying that because I go to a lot of seminars and you're really almost forced to sign up for a trust on some of these.
They're high
seminars.
pressure.
Very
Yeah.
high pressure. And it's so refreshing to hear a professional be upfront about it. So
And-
thank you for that.
And of course, they make them sound great. And in the
Yeah.
majority of states, they can be great assets. You know, you live in Florida, a trust can be great. But unfortunately, the relationship between trusts and Pennsylvania tax laws kind of defeats their benefits.
Are the trusts what some people do because they're trying to spend down their money to protect it from, if they would need long-term care, or why do people
So
use trusts?
a lot of people try and use trusts because they say if I put it in a trust, it's not going to be subject to inheritance tax. But again, is if you receive any benefit of it while you're alive, or if you have the ability to change any of it, it's not going to be protected from inheritance taxes. And when it comes to Medicaid, they look everywhere. That if you have the ability to receive income from something, it's counted as part of your allowable income. So a trust generally does not protect for Medicaid purposes either. So what people set them up for, maybe they do, but it doesn't actually help them then.
What would be the,
Yeah. In Pennsylvania, the biggest benefit to a trust, again, is those irrevocable trusts that you take some of your assets that you have decided you truly do not need. They are disposable, but you want them to go to certain family members or organizations. You can put them into that irrevocable trust, completely separate them from you. They're going to go to those individuals in accordance with the trust provisions, whether it's broken up over 10, 15, 40 years. And those distributions would not be subject to the inheritance tax laws because you are not a beneficiary or having any control over them anymore.
You address gifting to the church?
So gifts to charities are excluded from taxes. They're not excluded from lookbacks. So that lookback for Medicaid, you give to a church, you give them $20,000, Medicaid's going to say, well, if you gave away $20,000, you're now penalized for that. You don't qualify for Medicaid yet because you gave away assets without receiving fair value.
Okay.
Additionally, bequests to charities and nonprofits in your will, those get taken out free of inheritance tax as well, and they're deducted prior to calculating whatever is subject to inheritance tax. Yeah.
I have a question about the health, power of attorney. Say my husband and I both have the same person in charge of our health power of attorney. And that person thinks that my husband should go to a nursing home and I think he shouldn't. When does that power of attorney take over if the spouse wants for their partner?
When drafting these documents, I generally encourage spouses to name the spouse as the first agent. That gives you that kind of contractual legal right to still have the first say in what's happening with the spouse. Because in the event that you would create an attorney granting agency over somebody who's not a spouse, that's a contractual document there, and it's legally binding that says this agent has the authority no matter what the spouse is saying. And it can get into litigation, needless litigation, if there's some debate or conflict of what the spouse wants and what the agent would want. So when I draft them, if it's a married couple, unless there are existing health concerns that would give reason to not name a spouse, dementia, anything like that, we name the spouse first and then an alternate agent.
Yeah, just to follow up on the trust question.
Did you go to a trust seminar?
Trust me, I did. No, if you wanted to take a chunk of your 401k or IRA and put it into a trust,
Mhm.
thereby reducing your own total
Assets. Yep.
assets, would a long-term care facility be able to?
If it was set up to give control
Yeah.
If
with no control.
Would a long-term care facility be able to use that? Now, you mentioned inheritance taxes would be subject to.
so the long-term care facility is never the one that's going to use your assets. It's kind of a misnomer that, I need to go into a care facility, I have to give everything to them. They don't want your stuff. They just want paid for the services they're rendering. So if your question is, will the long-term care facility use that? No. If your question is, will Medicaid evaluate it? Potentially. If it's within that 5-year, Medicaid, you see all sorts of decisions come down from Medicaid in their eligibility questionnaires. They may look at that and say, you disposed of a significant asset, you didn't receive any value from it, we're going to consider that a gift that is now going to exclude you from Medicaid at this point. There are kind of rebuttable presumptions, or that you can contest or appeal the Medicaid decision and try and fight that should not be, held against you. But it's all very situational specific to that asset. But the care facility itself does not come in and take anything. The only thing that they kind of intercept or intervene with is either Medicaid or Medicare, or Social Security. They may be a representative payee for your Social Security benefits, which just makes sense because if your income is going to be exceeding the required threshold for Medicaid, that benefit is just going to go right to the home first, and then any additional amount owed would come from Medicaid. Yeah. So does that answer that? Okay.
Who are you dealing with for Medicaid? What profession? Where is that happening? How is that happening?
So Medicaid is the state, it's Pennsylvania State Assistance Program. And when you say, how are you dealing with, so if you're going into a nursing home, they can help you apply for Medicaid, if that's your question.
So it's a government office that I'm communicating with. I'm trying to figure out the interaction that happens.
So you typically don't get like a person on the phone or a personal interview. It's all paperwork that's submitted and processed that way. And typically what would happen is if you're in a care facility that your assets are dwindling and it's looking like you're going to need Medicaid assistance, they would have a Medicaid officer or a healthcare representative in that nursing facility that will help facilitate the application process in order to get you applied and approved for Medicaid. And they always make sure that in that application, they're named as the payee so that any Medicaid benefits come right to that nursing facility to pay your expenses. Because it's a whole regulated field. If there are questions or you get a denial and need assistance on appealing that, or you want to look at really planning or just a second opinion on the initial application, that's when attorneys like Mike are very useful to help make sure that this is getting applied for correctly and honestly.
So you go to a special attorney, specialized attorney.
An attorney who has like the Medicaid experience, yeah. But you don't have to go to them. Like I'm saying, it's not a one avenue requirement. It's just a form that needs to be sent into Medicaid. How you go about completing and submitting that form is really any number of ways.
Yeah, my experience with that, the people in the nursing homes, the social workers are very on top of Medicaid.
Yeah.
And they will guide you through everything to do, and if you have a question, you call them. They're really,
The good ones. If you, yeah, no,
we're so blessed. We have 17.
we do.
Most of them are really good.
Yeah. If you would get in the situation where the representative you're talking with seems to start stumbling or not really know, that's kind of a sign that you should go consult with a Medicaid attorney, just to make sure that everything is being handled correctly and submitted correctly. Because the initial application is your best shot at getting the approval. If you do it wrong and you get denied, it's a headache to appeal it and ultimately have them reverse their decision on approvals. So, yeah.
529 savings for grandchildren.
Mhm.
You get into anything like that at all?
So those are more kind of financial planner type questions. They're not assets of yours; they're assets of the child. Technically, you may be the one contributing to them and able to deduct the tax benefit on, but it's not your asset.
Would that be just like a gift though? Like, would it be limited to that 18,000 to put in the 529?
It is, from my understanding, limited to that 18,000 per year because it's a gift that you are making into this plan for them. But as I said, that's a whole different kind of realm under the tax laws, in which if you want to increase or adjust kind of how you're contributing to or funding a 529, speak with a financial planner. The name I threw out earlier, Landis Financial, they do that as well. That they kind of oversee all those sorts of financial and Medicare needs. Yeah.
I don't know. Are you familiar with IRMA? It's the increase in your Medicare premium if you make a deduction from an IRA that pushes your income up. And I'm like
Tangentially,
unfair question. My question is, can you appeal that if it was a one-time thing?
you can appeal anything. Whether or not you're successful, I have not seen that done. I have not seen an appeal and an ultimate decision on those distributions. So,
Yeah, thank you.
so you can appeal it.
Yeah.
Don't know if you'll be successful. Yeah. Anything else? I'll make sure I don't take up too much of your time. Were there any other questions or areas of concern? No? Well, then I thank you for having me. If there are any questions or things come up, feel free to take a card. Again, my card and Michael Grob's card is over there, that we're happy to answer any questions or have sit downs and review your situations if need be and help get you to where you want to be.
Thanks.
All right.
Thank you.
Thanks so much.
Thank you.